Welcome back to the Black Table here on the Black Star Network. This is our weekly hour devoted to topics, to subjects of particular importance to people of African descent and to others fighting to build a better society. I'm your regular host, Greg Carr, and we are continuing this week a conversation we began last week with a discussion of two of the latest important cases before the Supreme Court of the United States for the 2022-23 term. If you've been following our regular legal roundtable, you know we've discussed some of the watershed cases over the first half of the term, affirmative action being, of course, one of the more prominent ones, but not the only one, the Indian Child Welfare Act and many other cases. And in our first part of this discussion, we discussed the case before the Supreme Court involving something called the independent state legislature theory, Moore versus Harper. And we got so deep into that conversation that we decided to postpone the conversation we're going to have primarily today for today. And that is a conversation around freedom of speech. Is it about freedom to contract in goods and services? But it is arguably the most important First Amendment case before the Supreme Court in quite some time. This is 303 Creative. 303 is the former area code for the Denver, Colorado area. Lori Smith, who's the owner of a website design company called 303 Creative, versus Aubrey Elenis. Aubrey Elenis is the director of the Colorado Civil Rights Division, and he is representing the state of Colorado in their attempt to uphold the Colorado Anti-Discrimination Act. Is a very important case. The question at the heart of that case, whether a public accommodation law, like in this case, the Colorado Anti-Discrimination Act, can it compel an artist to speak or to stay silent about something that they believe in, and whether or not speaking or staying silent as a result of coercion by the state violates the free speech clause of the First Amendment. And that's one way of putting it, but really it's about a whole lot more. And we're going to have our conversation today about 303 Creative versus Elenis with our regular legal roundtable, Professors Valethia Watkins of Howard University and Angie Porter of the Washington School of Law at the American University. Welcome back, professors.
Hello.
Good to see you. Hello.
Washington College of Law.
Washington College of Law. Did I say School of Law?
Yes.
Sorry. That's because you are a proud double alumni of the Howard University and, of course,
School of Law.
The Howard University School of Law, known as Hustle in the Ebonic streets. But at any rate, so welcome.
And it was a great summary you just gave too.
No, look, that was just a tee up. I can't wait. We have a conservative supermajority on the Supreme Court that seems very eager to entertain these religious extremists. I'm sorry, conservatives. I think that's the more conventional language that are used. And we've seen, you all have walked us through so many cases over the course of the first half of this term. We've seen the dissents, which seem to be laying down markers for the future, so deeply invested in those Civil War amendments, those Reconstruction amendments, the second Constitution, as the guest we'll have early in the year. Kermit Roosevelt, who is at University of Pennsylvania School of Law, often talks about. But we see this majority, this conservative majority, seeming hell-bent to engage in, I don't know, I might call it the MAGA constitutional interpretations. But let's get right down to the issues here. What are the issues? First of all, 303 Creative, what are they arguing? We saw this case argued at the district court. We saw it, the ruling for the state of Colorado affirmed on appeal, although by a very interesting kind of theories that the 10th Circuit Court of Appeal wrote as they affirmed the lower court. But then we saw the Supreme Court of the United States taking this case. So I guess I would open by asking either of you to give us a summary of how we got to the Supreme Court, and maybe even your opinions on whether or not the Supreme Court of the United States should have even taken this case to begin with. Either of you can start, please.
Well, I'll defer to Professor Porter.
Oh.
Right.
Well, I think that during oral arguments, it was made clear that 303 doesn't even know what they're arguing. Okay, we know what they want,
Wow.
which is to discriminate. Okay, That's what they want. They really, really want to discriminate really bad. And so they are couching this legal argument in the First Amendment. This is not a religion case in terms of the legal argument. It is a First Amendment case, and it's a case about public accommodations. And I think we should step through, public accommodations law at some point, but I'll just go back to the original answers. They don't know what they're arguing, and it was made very clear during an exchange between Wagoner, who's counsel for Lori Smith, this website designer who wants to discriminate, and Justice Barrett, because at one point Justice Barrett gave this lawyer some hypotheticals and asked the lawyer, okay, well, would your client, 303 Creative, would she make a website? Because her whole stance is she's not going to make websites that represent same-sex marriage, because that goes against
maybe if you don't mind, Prof.
Yeah.
Because the press in a 30-second soundbite would say that it is about LGBTQ rights. And so you're saying you got a website designer, and what's her position again? You said it quickly there.
She doesn't want to make websites about same-sex marriage.
But she did say she will. If you're LGBTQ, she won't refuse you services. She just won't make a website if you decide you want her to design a website on same-sex marriage. Is that
right? That's part of her argument, is like, I have LGBT clients, just I'm not making marriage websites for them.
So is it or is it not a discrimination case then? She says I got LGBT clients. I mean, okay, go ahead. I'm sorry. That's right.
I guess so that's part of their argument, is that they're like, we're not discriminating against the people. We just don't want to endorse this message, or as you explained, Greg, we don't want to have compelled speech saying that we support same-sex marriage. And so they're saying, they want to discriminate about the conduct, not the people. But then Barrett gave her these hypotheticals. And one of them was, hey, what if a heterosexual couple comes to you and says, hey, we don't care about gender. It's a man and woman getting married, but they have a whole thing on their website that says, we're heterosexual, but that's irrelevant to our love. Would you make a website for them?
What did her lawyer say?
The lawyer said they would. And then
so just to be clear here, not everybody, but many people are being led to believe that this is a case about discriminating against gay, lesbian, queer folk, when in fact, while that might be the point of entry that got them in court, the real issue here is speech. Is that what in other words, there's much deeper issue than just the group.
Oh yeah. Okay. I'm coming there.
Okay.
This case is about segregation. This case is about we want.
Oh, wait a minute. Hold on now. Wait. Okay, let me be quiet. Go right ahead.
Yeah. Okay. We're gonna get there. That's why we spend a whole session on this. But I guess what I'm trying to say is it goes back to what we discussed last week. This is all results oriented. This is not about a cogent legal argument. Barrett gave her that hypothetical to say, hey, would you make this website even if the couple is saying things that you don't believe in? Because you're discriminating against the message, not the people. But the lawyer conceded that they would make the website for the heterosexual couple. Barrett, confounded, posed the hypothetical again, saying, I think you meant to say you would not make that website. Then the lawyer said, oh yeah, you're right. My client would not. They don't even know what they're arguing.
But
and the justices have to help them, the conservative justices, help them make their point that they're trying to discriminate on the sly.
So help me. Is this a sense, Professor Watkins, given what we just heard Professor Porter lay out, is it your sense that they were just determined to take this case anyway, right? Because, I mean, first of all, let me ask you, what was the act of discrimination that 303 engaged in that brought them into court in the first place?
So that is the question, because the state of Colorado has not moved to, first of all, let's take a step back. She has not created the website business that we're in court debating about.
Really? But I saw LLC at the end. What do you mean? There's no business?
Right. She's thinking about, this is a a prospective business she's thinking about creating.
What?
And so, yes, this is, in many regards, the court would normally say, hey, you don't have standing, or this issue is not ripe yet. We don't have a controversy because the state has not made you do anything. There is no victim in this scenario. No one has come to you and said, build this website or else. And the state has not penalized you or held you accountable for anything because you haven't done anything yet. And so
first year law students and young people deciding to go to law school. We've covered this many times before at this legal roundtable. What you heard Professor Watkins say, the question of standing, you have to have had some harm before you can go to court. But in this case, you're saying not only is there no harm, there's no company to be harmed. But see,
this is part of why they did this under speech, because the First Amendment doctrine has a lot of permutations, and standing has a couple of exceptions. One being if the issue is capable of repetition yet evading review. And so there is such a thing as a pre-enforcement action. That's what this is characterized as. And it's this idea that people's speech will be chilled or they will be compelled. And so the thing hasn't happened yet, but courts, I think, contemplate that chilling or compulsion as an injury in itself.
Very good.
But that's what makes this, that's why we had the battle of the hypotheticals. And that's what made it difficult for them to envision what is the line? Where do you draw the line? Where is the red line? Because there is no record to begin to give parameters to that. So this in really regard is that another example of the court moving at a breakneck speed to take away legal protections that have been in place. And it's going to open the door as if the last 50 years of jurisprudence did not happen.
Let's pause there. That's a good place to pause. And when we pick up after the break, we're going to pick up right there. We're in the courtroom. We're entering the oral arguments of 303 Creative versus Elenis. And we've heard not only what's at stake, but maybe even gotten a glimpse as to why they are determined, and they being this current Supreme Court, to not only hear this case, but to maybe even coach their friends on the other side to reach the desired result. So back in a moment here at the Black Table on the Black Star Network.
Black Star Network is here.
Oh, no punch!
I'm real revolutionary right now.
Thank you for being the voice of Black America.
All momentum we have now, we have to keep this going.
The video looks phenomenal.
See, there's a difference between Black Star Network and Black-owned media and something like CNN.
You can't be Black-owned media and be scared.
It's time to be smart.
Bring your eyeballs home.
You dig?
Welcome back to the Black Star Network's Black Table. I'm your regular host, Greg Carr, joined by Angie Porter and Valethia Watkins, our regular legal roundtable. And we're discussing 303 Creative versus Elenis, the latest in the seismic cases before the United States Supreme Court, argued earlier in December 2022. Professor Watkins, you brought us right up again into the courtroom for the oral arguments. This conservative supermajority seems hell-bent on I don't know. It sounded like coaching, Professor Porter. I mean, could you continue in this? So they're trying to. Anyway, let me get out of you all's way. Continue in this conversation about what went on in the orals during 303 Creative versus Elenis. We've gotten the sense of well. Before we do that, how did the lower courts decide? They decided to take the case. What did the district court do? What did the Court of Appeals do? And how did we get to the Supreme Court in the first place?
Well, if I actually might back up even further than that,
no, please, by all means.
to talk about public accommodations law.
Yes.
Because that's what's at issue here, and the legal side. what's at stake, as I said, is segregation, but we'll come back to that. What's at issue is public accommodations law, which is related to segregation. So the Civil Rights Act of 1964 happens, and Title II of that federal statute prohibits discrimination on 4 grounds in public accommodations, and that's race, color, national origin, and religion. That happens in 1964, basically attempting to end Jim Crow. A lot of people think that that act banned discrimination across public accommodations everywhere. It didn't, though. Public accommodations, too, by the way, doesn't just mean government buildings. It means any business that holds itself out and serves the public, holds itself out to the public. So that's restaurants, hotels, movie theaters.
So if I want to sell a barbecue sandwich to anybody I want, I don't like black people, so they can't eat barbecue. If I'm selling to everybody,
you brought up Ollie's Barbecue, which comes up during oral argument. That's
Ollie's Barbecue.
That's a famous case, Katzenbach versus McClune, that Justice Sotomayor raised during oral argument, because that is how related that issue you just described is to this case. But yes, that's what we're talking about. If I want to serve black people, Civil Rights Act of 1964 regulates that. But federal statutes can only apply to businesses in interstate commerce. So Title II of Civil Rights Act of 1964 says this. This is when you have motels serving interstate travelers. You've talked about Heart of Atlanta Motel. That's another case.
I'm glad you said it, actually. I'm glad you reminded me, because there's a new book on Heart of Atlanta Motel, and I'm glad you made that note. I'm going to invite that author on to talk about that Atlanta case. But go ahead.
You should. Yeah. But so what if your business is not in this idea of interstate commerce? The states are the bodies that create laws or statutes that ban discrimination in public accommodations. So that's why we have a state law here, Colorado, that bans this type of discrimination. And they're not limited to interstate commerce. They are regulating all the businesses in their state.
Yes.
So here we're talking about not only sellers, but creators, artists, like website designers, cannot discriminate on the basis of, and then there's all these enumerated grounds: race, sex, national origin, color, disability, sexual orientation, which is an issue in this case, and gender identity, things like that. I think Colorado might just do sexual orientation, though. And half the states have that enumerated list. Other states have longer lists. Other states, 5 states don't even have public accommodations law, like Texas and Georgia.
So they have, just interesting, because I guess, 5 years ago that they had the cake shop case in Colorado. What is it about Colorado? And I know you're into the ADF, who these people are, the Alliance of Defense of Freedom or whatever, that's bankrolling these people. What is it about gender? And what is it about Colorado that has made this low-hanging fruit? And why didn't the Supreme Court take a case like this 5 years ago? They had that case, right?
Mm-hmm.
So, and I guess everybody's probably thinking as well, a cake shop designer is an artist, a website designer is an artist. Anyway, so go ahead. I'm sorry.
Right. And speech too, and the things that they're doing are speech. Now, I just say the First Amendment is a lot more complicated than a lot of people think. Mm-hmm. And it has a lot more exceptions than people think. My con law professor in law school back in the day, Ziad Matala, told us it's like Swiss cheese. There's so many carve-outs in the First Amendment that it looks like Swiss cheese. So there is such a thing as symbolic speech. And so this isn't really a controversial thing. Art can be speech, and you can be compelled to speak. The big case on that is the Pledge of Allegiance case. Where you can't force people to say the pledge. They don't have to.
Your Board of Education versus Barnett. You can't force anybody to make the Pledge of Allegiance. That was the 1940s, though.
Yeah.
So what do we? When we're talking about this case before this current court, you said you led with this. It's really about wanting to discriminate.
Yes. So the reason I laid out this public accommodations laws, Civil Rights Act of 1964, Colorado, is because they have these enumerated categories.
Yes.
And if you listen to the oral argument, you would have heard Eric Olson, who's Solicitor General for Colorado, say to Justice Jackson, there is no way to cabin this. If you use this legal analysis under the speech doctrine, there is no way to cabin this to sexual orientation. So we're not just, there's no way to limit this. You have these statutes that list these categories: race, sex, sexual orientation, religion. You can't just distinguish them. If you say we can discriminate against one, you're saying we can discriminate against all. So if you say that Lori Smith can turn away same-sex couples and say she doesn't need to make a website for them, then you are also saying someone can turn away Black people at all these barbecue because they don't want them in there. They don't want to feel compelled that they endorse having Black people in their restaurant as a message, as a speech message. So how do you contain this?
But if I'm an artist, I can make art that communicates these things. Why, is it the commerce dimension of it? Is it the public not just public accommodations? Is it goods and services? As an artist, I can do whatever the hell I want to do. But once I go into the marketplace, then I have to sell?
And see, that's another murky part of this. That's part of why Colorado is saying, like, analyzing this as speech is disingenuous and doesn't make sense, because they are trying to carve out, like, this is only artists. This isn't like restaurants and sellers. This is only, this very narrow service. And public accommodations law applies to services as well. So sellers of goods and services.
Professor,
but that's like a made up category, and it's not clean and it's not working. And so we get all these hypotheticals, which I know we're going to talk about, because the justices are grappling with just how expansive this notion of an artist or creators are. Because is she an artist? I mean, she's making websites. Right. I guess someone might say that's art. But others would say that is a service you are providing to the public.
I mean, I'm a chef, and I went to chef school, and I'm an artist. So therefore, but I want my art consumed by Latinos, because I think that they don't, they somehow don't have the palate. But Professor Watkins, as we kind of come to the end of this session and we're going to next segment rather, we'll get into these orals, because these hypotheticals were buck wild, and I know y'all just chomping at the bit to talk about them. Professor Watkins, so before we do, certainly it is Lori Smith and 303 Creative in court, but who are these Alliance Defending Freedom people? Because they not only funded her, they funded this previous suit in Colorado. I don't know if you have any thoughts about the context in which we even find ourselves, given what you just said earlier about the fact that she hadn't served anybody yet. She's just thinking about it.
Right. So these are conservative, right-wing judicial activists who want to use these test cases to bring about a change in the law that would give the right to discriminate. But of course, if they're overt about it and say the issue with this Lori Smith case, for example, it's all wrapped up in free expression and freedom of religion. That is the basis of the argument of why I don't want to provide this website. It goes against my sincerely held religious belief. But yet the court, when it decided to take this case, did not agree to take it on religious ground, agreed to take it only on freedom of speech ground. So is that really a head fake? Because it's really grounded in, this is my religious belief. So when they decided the Masterpiece case in 2018, it was still him making the argument. My cakes are my creative expression, my artistic expression, and you cannot compel me to, use my art and give messages that do not comport with my religious belief. But the court decided that case on very, very narrow grounds and avoided the broader religious question. So this case has much wider implication. It appears to be very narrow, but it is as Professor Porter says, the implications are greater. And KBJ, Justice Jackson, implicated that lest we forget or have historical amnesia, the right to discriminate against Black people based on race, on Jim Crow, many of the same arguments based on my sincerely held religious belief that God commands me not to support integration. God commands me not to support interracial marriage because the races should not be commingling in that way. Those same arguments were used to justify Jim Crow segregation and to deny Black people services and access on an equal basis to services. So this case has wide implication. It is not as narrow as they would like us to think. And secondly, they frame it in ways as if these categories are walled off from each other, that people have overlapping identities. And so even the implications are deeper and more entangled in that way. So the question is, what tests will they use? Like they made the argument that the person can have her own personal beliefs, her own website beliefs. She could state it on her website as her belief. But when she's offering to be a platform for people to now save the date, or this is the room where the event will happen, is she really expressing her view, or is she expressing her paid client's view? And that's where you get the murkiness of this whole thing.
Okay, this is very useful. So we're going to take a momentary break. We're going to come back on the other side. And I know folks are saying, when you going to get to the arguments they had in the court? That's in the next section. So get ready. When we come back, we're here at the Black Table. Professors Angie Porter and Valencia Watkins going to take us in that classroom. The classroom, I shouldn't have said that, but to the courtroom. The courtroom for oral arguments. Right, it's both, I suppose. So we'll be back here in a moment here at the Black Table on the Black Star Network. Back in a moment.
Hello, I'm Isaac Hayes III, founder and CEO of Fanbase, and I'm here with a very important message. We are at a turning point in the Black community where we must have equity in the apps we use that scale to billions of dollars. But this time, we own the infrastructure, we own the culture, and we shape the future. And Fanbase is the future. Fanbase combines the free functionality of Instagram, TikTok, and YouTube into an all-in-one platform built for the evolution of social media and monetization. With over 1.4 million users, that's real proof that we are shifting the conversation of tech ownership and equity for creators. So right now, I want you to go to startengine.com/fanbase and invest today. The minimum to invest is $399. That gets you 60 shares of stock in Fanbase at $665 a share. This marks a turning point in Black ownership of social media. If we don't take this opportunity to own social media right now, we will always be customers to our own creations. And that can't go on. So once again, go to startengine.com/fanbase and invest today. We must own the platforms where our voices live, our stories matter, and where our culture drives the world. Thank you.
Welcome back to the Black Table here on the Black Star Network. Remember to support the Black Star Network across all platforms, whether you're watching on YouTube or Facebook, whether you're streaming on or over-the-top channels, Roku and so many others, Amazon, Fire Stick, all that. But more importantly, download the app, the Black Star app, so you can have access not only to the Black Table, but to all of our shows, our daily and our monthly shows. The network is growing, and it's thanks to you. So let's continue in our conversation here at the Black Table with Professors Angie Porter and Valencia Watkins. Let's go in that courtroom. You all laid out at the beginning. Talk to us, Professor Porter. What now? So we're at the day of the argument. You've already teased some of the things that we discussed. Continue, please, by all means. 303 Creative versus Elenis. We're sitting here in December. May it please the court. So go right ahead.
Well, I would like to invite both of you to step through in slow motion with me the highlight of this oral argument, which is a kind of a three-part situation. But we have to start with KBJ, and how, as we have teed up, she goes to talking about race. Now, normally, and I talk with Dr. Watkins about this all the time, normally I get all upset because they always use our people to use your framework, Dr. Carr, in these social structure conversations.
Yes.
They always draw our people in as a straw man argument. They don't actually care about us. And we don't care that they don't care, but they posture like there's so much compassion about Black people. And they're just using us as a straw man.
I mean, I have to inject here very quickly that I remember when they argued the Prop 8 and the DOMA cases, the gay same-sex marriage cases, and we were all down in front of the Supreme Court, and it was a rainbow of people, and Black speaker after Black speaker after Black speaker. And the day of the decision, I went back down to the sea, and it was a sea of white. I'm like, where are the Black people? I don't get so much. Every other word was the 1967 interracial marriage case. It's like, but then I'm like, what? Go ahead. Sorry. So KBJ leads out the Black.
Yeah.
Yes.
Well, and I guess I was going to say, but in this case, as we've already discussed, we have statutes that lay out these categories. Yes. So we get all these hypotheticals. Hypotheticals, by the way, are a common feature of legal argument generally, but definitely at the Supreme Court. You see hypotheticals happening all the time because we're trying to figure out the contours, how expansive, how narrow is the rule going to be. But we have to test these different identities, as Dr. Watkins laid out. So here's the first thing I want to step through with you all is KBJ's hypothetical. She tees up one that is known now as Scenes with Santa. Scenes with Santa.
Merry Christmas.
Merry Christmas.
Merry Christmas.
We're going to the mall, and there's a shop, and they offer photos. Scenes with Santa. It's like 1940s, nostalgic, she says. Santa scenes, but it's like It's a Wonderful Life. I've never seen that, but
oh my God,
no Black people. No Black people.
No, that's a favorite.
I know.
Oh my God, that was a classic reference. Every year it comes on. Oh yes, that was so on point.
Come on, what's wrong with you, Professor?
I know. I'm gonna watch it this year. I'm watching this year, but I'm watching this year so I can understand this.
Okay, because there's only one Black character, is the Professor Watkins, the maid, I think Annie. I've been saving this money for a divorce if ever I
and gave it all.
Right, gave it all to the white man. Yeah, anyway, maybe not. Maybe not. It's okay.
So there's one Black character. Okay. Well, anyway, she's like,
no paying attention. She was the maid in the house with Jimmy Stewart's maid. So I mean, it's now mind you,
but that's why it's on point as a point of reference. She's like, if you want to recreate It's a Wonderful Life, there basically are no Black people there, and that's why the person who's setting up this can say, I don't want the little Black children in the scene because it's not on point with the actual time I'm trying to recapture.
Scenes with Santa, you got a white Santa and white. Now our wizard producer, who is also a master of graphics, Keenan, I'm not going to suggest perhaps that he finds an idyllic white Santa with two white children sitting in his lap, but there are Black Santas, right? I mean, I'm sure you probably saw a Black Santa, Professor Porter, since you were a little younger than.
My mom used to collect Black Santas.
Oh really?
Yes, for the children in our audience, Santa is of Black origins and white origins. He's in the imagination of every child. He reflects them and their
every person.
Well, he better, because as Naeem Akbar would say, if you have a home invasion on December 25th and a white man comes down your chimney, he might get a behind full of buckshot. So anyway, so you better make him Black if he coming in your house in the middle.
He better be, yeah. Okay, so Scenes with Santa, they're like, hey, It's a Wonderful Life. You can't come up in here. She says, all people of color. So all non-white people get turned away in her hypothetical and sent to the other side of the mall to take pictures with, open Santa, Santa who can just regular Santa who can take pictures with everybody.
You got Santa who everybody in the world can take pictures with, and you got Clan Santa.
Right. We're gonna come back to the Klan.
Okay. All right.
And remember, but this aligns with what Lori Smith is trying to do in this sense. The point is, she's like, well, they would take the Black children for other scenes. It's just this specific scene is her artistic expression of the It's a Wonderful Life, that specific time period.
Yes.
So that's the problem. It opens the door.
That's why this is an analogy, this hypothetical. And so KBJ is asking, okay, so is that okay? She has shifted Laurie Smith's situation to race, which is a lot more stark and salient in supposedly. And so the lawyer, Kristen Wagner, when asked by KBJ, is this okay? She says she thinks it's maybe an edge case, meaning it could go either way.
What?
And KBJ and Kagan jumped on her. They were like, an edge case? What? So that's where we are. That's where we got a lawyer. You're at the Supreme Court, y'all. And you're like, yeah, that can maybe be okay for scenes with Santa.
Now, I just left Atlanta, and the huge, bigger than day picture in one of the many Black malls in in Atlanta, where there's a Black Santa smiling with two Black children, one on each knee. And I thought to myself, this is what they were talking about in 303 Creative. But you're saying that Black Santa could refuse to have white children on his lap?
Okay. So we haven't gotten there yet. We're just in scenes with Santa. We're just with white Santa saying, you Black children, you can't come in here. Okay, so that was slow motion step number one.
Uh-huh.
This is how we understand what Alito does later. So Kristen Wagner sits down. Eric Olson, who represents Colorado, comes up, and he's doing his argument. Now here come Alito. Because Alito can't leave it alone. He's like, I want to return to Justice Jackson's hypothetical. Scenes with Santa.
What?
I'm going to tweak it a little bit. Now, they regularly do this, but we know that Alito is obsessed with race.
Yes, he is.
And he don't like Black people. All right.
Not just Black people. Y'all go back and listen. Those of you who are watching this, go back and listen to the oral arguments in the Indian child welfare case. You will lose your mind listening to Sam Alito talk about the Indians and how they was fighting each other till the Europeans came and civilized them pretty much. This guy's off the chain, yo.
He's off the chain. Let me clean it up. It appears as if he don't like Black people. It seems like he don't like Black people.
I don't know, by the words out of his mouth.
I don't know him.
No,
but he act like he don't like Black people. So he's like, let me tweak this hypothetical. What if Black Santa at the other end of the mall?
Oh, Atlanta Santa does make an appearance. Okay, go ahead.
What if Black Santa, and going back to what Dr. Watkins said, they're doing this because we're doing creatives. So we're talking about people creating photos. Laurie Smith's creating a website. Santas are doing photos. Okay. What if Black Santa is confronted with a child dressed up in a Ku Klux Klan outfit?
What? What was this man smoking before? He didn't say that.
He said that, and I'm like, what holiday? I know y'all like to dress up in Klan outfits for Halloween, but I didn't know Christmas was also.
Look, it sounds like he grabbed the wrong robe when he went to sit on the bench that day. So
the wrong robe, Professor.
He grabbed the black robe, not the white robe. Oh, he grabbed the white robe.
Wow.
Mm-hmm. Yes, and so Elena Kagan weighed in and said, but hold on, Professor Watkins. Okay.
Can we come back to that in a second?
We don't have.
We don't want to brush past that.
Okay.
Go ahead.
Let's just wrap this one up quick, and you can take us back to what Kagan said, because that's important. But why does he say? Why does he pose this hypothetical? What's his agenda?
Yes.
And he's trying to again use race and say, well, that's a terrible thing. Of course, you would say the Black Santa should be able to turn that kid away, because you guys care about race so much. So in the same breath, Laurie Smith should be able to turn same-sex couples away. That's his whole, agenda with this hypothetical with Black Santa. Because using Black people as a straw man.
Klan outfits and LGBTQ persons are, of course, the same.
Well, and this comes before Kagan's comment, which Dr. Watkins will bring us back to, but every lawyer who knows public accommodations law or can read a statute knows this. And Eric Olson swiftly cut this down in one sentence. And he says, yeah, that's okay for Black Santa to turn Klan kid away because a Klan costume is not a protected category.
Okay.
Meaning it's not race, sex, sexual orientation, religion.
Klan outfit.
It's Klan outfit, right? That is not on the list. That is not on the list. And so since it's not on the list.
It's not protected.
Right. Your Klan uniform is not a protected status.
I can turn away Klan outfits.
Although it sounds philosophically as if they're trying to bring it into protected status, which is where we're going to come back. After we come back from this last break, we're going to come back and bring all this home. 303 Creative versus Elenis. So we'll be back here in a moment. Black Table, as we finish up our legal roundtable on this case. Back in a moment.
They said the quiet part out loud. Black votes are a threat, so they erased them. After the Supreme Court gutted the Voting Rights Act in 2013, Republican legislatures moved fast. New voter ID laws, polling place shutdowns, purges of black voters from the rolls. Trump's Justice Department didn't stop it, they joined in. In 2018, his DOJ backed Ohio's voter purge system, a scheme that disproportionately erased black voters. Their goal, erase black votes and political power. Yeah, that happened. These are the kinds of stories that we cover every day on Roland Martin Unfiltered. Subscribe on YouTube and download the Black Star Network app. Support fact-based independent journalism that centers African Americans and the issues that matter to our community.
Welcome back to the Black Table here on the Black Star Network. I'm your regular host, Greg Carr, joined by our legal roundtable, Angie Porter and Valethia Watkins. Y'all remember to support the Black Star Network. We're not going to have a conversation like this anywhere else. So let's come on back. Scenes with Santa is really kind of bizarre at this point. So we have about 10 minutes left. So let's get after it. So
Dr. Watkins, go ahead. And we're not in Scenes with Santa anymore. We're in Klan Kid.
Oh yes, Klan Kid. Yeah, Klan Kids. Yeah. Well, right. Santa versus the Klan. I mean, well, anyway, but go ahead, Professor Watkins. What did Alana Kagan say? What did Justice Kagan say in response to Alito talking about these Klan outfits?
You do see a lot of black children in Ku Klux Klan outfits, right? All the time. Suppose that.
Well, I mean, she was just adding whether the race of the person wearing the Klan outfit, if it was a black kid or a white kid. The point is the Klan outfit did not have protected status, and so therefore it doesn't change.
Black. I know the movie Black Klansman. You said Black Klan kid, a black kid in a Klansman?
Right.
Bigsby.
Right. And then that.
Oh yeah, that's true. What?
Then that gave Alito another punchline. And I think his very casual racism in that sense was not just as jarring, but what was equally as jarring was the belly laugh that you heard so many in the audience give in response to his, and we know black children wear Klan outfits all the time, or something to that effect.
Yeah,
was very problematic and very insensitive.
So Kagan said it isn't the outfit, it's also the race of the person. So I mean,
no,
the opposite way.
Go ahead.
Kagan says,
yeah, go ahead.
Oh, okay. Kagan says, and it wouldn't matter what race the child is underneath the Klan outfit. Right. And she's saying that because she's making a legal point here. Yeah. She's saying it truly is the outfit that is being turned away here. Yeah. This is not race.
Klan outfit
is not a protected
swastika. It wouldn't matter, right? Some of those Proud Boys were not white, but again, it's the swastikas, it's the Klan out. Right. It wouldn't matter. Okay. And then Alito jumps in and makes a joke.
He laughs and he says, Oh yeah, because we see Black children in Klan outfits all the time.
Professor Watkins, you can hear earned oral arguments, laughter in.
Oh yeah, absolutely. The courtroom breaks out in huge laughter.
Kagan don't laugh though. Kagan is not.
And I'm sure Brown Jackson wasn't laughing. I hope Clarence didn't chuckle, but you can never tell.
Kagan basically like, you're in hot water. You want me to get you out of the hot water? And he said yes.
What happened?
No, she intervened because she saw where that statement was problematic. And she's like, you want me to get you, basically saying, you want me to go ahead? Because you're in trouble with that statement, buddy.
Yeah. Well, and here's the thing though, too. Like, so he makes this terrible joke that's offensive. You don't want to play with this because white children are attending lynchings, public lynchings. You got postcards of little white kids smiling with burning Black bodies in the background. And you got little white kids today being indoctrinated in things that are equal to and worse than the Klan. So,
and you're teeing up cases where you've got people all over the country, school boards and others, trying to ban books that if they talk about that, they say that that's racism and critical race theory. Wow. So the country is being very much well primed for white children and others to be socialized to have exactly that kind of Klan mindset. Exactly. That's right. This is no joke.
This is no joke. And he's also, in his joke, is like, you don't see a lot of Black kids in Klan outfits. Do you see a lot of kids in Klan outfits, period?
Right.
So, Alito, right. Okay, I guess you do. But here's the sinister legal part. He, in this little joke, which seems offhanded, but I think was very calculated because he's a very calculating justice.
No question.
He is suggesting, by saying you don't see a lot of Black children in Klan outfits, that Klan outfits are essentially a proxy for whiteness. Meaning it is race. Meaning if you turn away some kid in a Klan outfit, you're turning away white children. Meaning it does run afoul of public accommodations law. Therefore, we should let Lori Smith do the same because that's, of course, Black Santa should be able to turn away white kids.
And then as we turn to the end here, the last 5 minutes or so of our conversation, Professor Porter, the point you made at the very beginning peeks out. Freedom to discriminate.
Mm-hmm. That's what this is all about. It's totally about taking down public accommodations law. And if you were listening carefully and you held on, because this was not the last that Alito hung on to this point. A lot of the sound bites ended there with this joke, but he comes back and he says to Eric Olson, so what if I'm in a state where the public accommodations law bans discrimination based on political affiliation?
Mm-hmm.
Now, this is a thing in some states. When I was practicing law, it wasn't a thing in my state. And I was so glad because the trend Dr. Watkins and I have been talking about in all of our conversation with you, Greg, is that the conservatives are turning the law that originally helped our people on its head. And they've done that with public accommodations laws and discriminations law, employment discriminations law, when they add political affiliation onto those laws. Because they can come to offices like where I used to work and say, I'm being discriminated against because I'm a MAGA Republican. And I used to be able to say, sorry, that's not one of the protected identities. But some states have added that as a protected identity. So Alito came back and he said, what if I'm in one of those states? Then does Black Santa, get to turn away Klan kid? And Eric Olson said, that would be a closer case. That would be an edge case. So in those states, Klan kid might have a right to take a picture with Black Santa, which isn't ultimately good for Lori Smith. But what I think is being done in these oral arguments is that the justices, and Alito does this a lot, Thomas does this a lot, they aren't really talking about this case.
No.
They're talking to people and giving them the blueprint for their movements, for their arguments.
Well, let's
So
take
it's sort of like whether this case is, good or what, they can go and move to get political affiliation on this list in all the states.
Let's talk about that in the last couple of minutes we have with both of you. Any thoughts on how this case do you think is going to be decided, and what are the implications across the field? Because we've certainly seen them try to slither their way out of gerrymandering by saying that these issues aren't justiciable political questions and so forth. I mean, affirmative action we see, of course, which we need to probably schedule another conversation around that. Now that these law schools are trying to drop their U.S. News and Report rankings, I want to know what you all think about that. But how do you think this decision? What do you think this decision is going to be, and what are its implications?
Well, I think that building on Professor Porter's argument about the straw man argument, using race as a straw man argument, they try to frame what they're doing as neutral, that is not favoring or putting their finger on their thumb on the scale for white rights. But that isn't exactly what they're doing. They're flipping the script, and they're using these anti-discrimination laws to not protect vulnerable, marginalized group, but to protect the white majority. And in their process to do this, they're undermining the state's rights, in this case, the state's right to protect vulnerable group and marginalized group. And it also will undermine the Civil Rights Act and other anti-discrimination act. And so with breakneck speed, this court is rapidly, in a very short time period, undoing a great many of statutes and laws that were the result of the civil rights movement to get to the result that they want. And that's problematic.
Mm-hmm. Mm-hmm. So go ahead, Professor. You got the last word.
Well, I think it just goes back to how we started, which is they want to discriminate. And what's at stake is segregation. There's a reason Justice Sotomayor raised that case of Ollie's Barbecue, Alabama, and a white restaurant owner being able to turn away Black patrons based on this convoluted speech argument. All of this stuff that we've discussed is results oriented. They want to be able to do what they want to be able to do with impunity. And they want to be able to live their values, and hide behind religion and hide behind speech to make America great again, return to a time when they didn't have to respect the rights of our people, regardless of as Dr. Watkins mentioned, the overlapping identities that our people have. I mean, Black people are facing full frontal assault from this court. And so every case is connected, and we really need to pay attention to how this plays out. So in this case, I'm going to be on the lookout for what Justice Alito is going to say in the written opinion, and just how expansive this is going to go. I don't think you can contain it. So
if I might add quickly, in the category race, these are not hypotheticals. This is the basic rationale that was given back in the day to discriminate against Black people. They use the argument of it is their sincere religious beliefs that desegregation or integration was violating their rights in terms of their religious liberty. So it's coming full circle. This is not hypothetical. It happened before, and they're using the same rationale that the court had turned away in the past.
Absolutely. Well, listen, I'm going to thank you both, because these are some nettlesome and difficult legal issues and principles at work. But what you're allowing us to do here is to have people be informed as to the underlying political, cultural, social issues, so that we don't get lost in the thicket of legalese, but rather are able to translate these things so we can see what's really going on. And that's not only a skill, that's a gift. So thanks, professors. Certainly here at the Black Table, there's a reason we keep asking you how to come back. You're able to translate these things, and it's brilliantly done. So thank you both in this for walking us through this very important case.
Thank you.
Of course. We'll be back in a moment to clear the table and continue our conversation here at the Black Table on the Black Star Network. Back in a moment.
violent white supremacy is, quote, the most persistent and lethal threat in the homeland.
The greatest terrorist threat to the homeland is the homegrown violence stream, including hate crime committed on behalf of some kind of white supremacist ideology.
They are coming after everything in Black America. MAGA and Donald Trump are specifically targeting Black America.
They are going after the money. Attack Black Lives Matter. Attack critical race theory. Attack woke, DEI.
MAGA wants to defund Black America. This is a perfect example of their desire to completely degrade and de-emphasize Black people.
Welcome back to the Black Table here on the Black Star Network. I'm your regular host, Greg Carr. We have been blessed today to have another session at our legal roundtable with Professors Valethia Watkins and Angela Porter. And they walked us through 303 Creative versus Elenis, a case involving freedom of speech, yeah. A case involving providing goods and services to the public, yeah. But a case about so much more. Underneath, a case about the nature and the continuing fight over the nature of not only the United States of America, but what it means to live in a nation state where different people from different backgrounds, different races, different cultures are in one place fighting to, some people, at least in their mind, build a better society, and some people build a better society by excluding some of those other people. And that is why we have to always remember that when we say nation state, when we say country, when we say our nation or the American people or the Nigerian people or the British people, you know, that's much more complex than just rhetoric. A nation is a concept that is drawn from the idea of common memory, common language, common culture. And the United States of America really isn't a nation if you define nation that way. It is, however, a state. A state is simply a political formation, a social construct, a formation where there are rules by which the people who live within that state, you know, they must conduct themselves. But the United States of America, as we see with this current Supreme Court and with many of the movements in it that have been there since the founding and are getting, as we heard Professor Watkins say, new life in some ways, define the concept of the American nation much more narrowly, even as the demographics continue to wash away those founding concepts of what this nation, so to speak, was. This has been a very important conversation, and it's not going to be over. We're going to carry this right on into and through to 2023, and I suspect we'll be convening the legal roundtable again sooner rather than later. Thank you for joining us here at the Black Table, and we'll see you next week.